Now we'll discuss question number 6, and that is, can buyer reject the goods for breach of a condition when goods have been accepted by the buyer? And the very answer to this question we found under section 13 subsection 2 of the Sale of Goods Act. So the very answer as provided where a contract of sale is not severable and the buyer has accepted the goods wholly or input, the buyer cannot reject the goods for breach of a condition. He can only claim damages. This is based on the principle that once a buyer has accepted the goods, he cannot reject them on any ground, but he can only claim damages. But the parties are quite free to provide otherwise in their contract. But where the contract is severable, as in the case of an installment contract, the buyer can exercise his right of rejecting the goods if a condition is broken, and he can reject the goods under any installment as it is provided under Section 13 subsection 2 of Sale of Goods Act. And now we'll go to question number 7, as it is whether a stipulation in a contract of sale is a condition or warranty depends on each cases on the construction of the contracts and discuss. So this very question and its very answer is that a stipulation in a contract of sale with reference to the goods which form the subject matter of the contract may be either essential to the main purpose of the contract or it may be only collateral to the main purpose. Where it is essential to the main purpose of the contract and the breach of it gives rise to a right to treat the contract as repudiated. The stipulation is called a condition, but where it is only collateral to the main purpose and the breach, it gives rise to a right to claim damage only. The stipulation is called a warranty. Where stipulation is a condition or warranty depends on the true construction of the contract. A stipulation of the contract. A stipulation may have been called a warranty in the contract but may in fact be a condition. The best way of deciding the question is by looking at the contract in the light of the surrounding circumstances and then making of one's mind whether the intention of the parties is gathered from the instrument itself will best be carried out by treating the promise as a warranty, sounding only in damages or as conditioned by the failure to perform which the other party is relieved of his liability. And now we'll go to our Next question, that is question number 8. What is meant by merchantable quality? When is a condition as to merchantable quality implied in a contract for the sale of goods? And the very answer regarding that, we would like to discuss also a very important leading case, Bristol Tramways Companies versus Fiat Motor Limited in 1910, decided by the King's Bench. And another important leading case relating to this question is Canada Atlantic Grain Export Company versus Elias in 1929. So the very answer under the Act does not define the word merchantable quality. Goods are to be merchantable quality if they are of such quality and in such condition that a reasonable man acting reasonably would, after a full examination, accept them under the circumstances of the case in performance of the offer to buy them, whether he buys for his own use or to sell them again in the market, as it was decided in Bristol Tramways Company versus Fiat Motor Limited in 1910 by the King's Bench. The goods cannot be treated as that of unmerchantable quality merely because they are unfit for any particular purpose. Because if goods are sold under a description which they fulfill, and if goods under that description are reasonably capable in ordinary use of several purposes, they are of merchantable quality if they are reasonable, capable of being used for any one or more of such purposes, even if unfit for that of those purposes which the particular buyer intended. For example, where barley was sold as feeding barley, but it was found unfit for feeding pigs, but was still fit for being used as feeding stuff for another animal. It was held that it was not unmerchantable goods. In the important leading case, Canada Atlantic Grain Export Company versus Elias in 1929. So, where goods are bought by description from a seller who deals in goods of that description, whether he is the manufacturer or producer or not, there is an implied condition that the goods shall be of merchantable quality. But if the buyer has examined the goods, there shall be no implied condition as regards those defects. Such examination ought to have revealed if the goods are unmerchantable, they called merchantable simply because they can be made so at small expense. The goods to be of merchantable quality must be so at the time of the seller's tender. And now we'll go to question number 9, and that is distinguish sale from velvet and from barter and lastly from gift. So, the very answer to question number 9 is that a bailment is the delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the persons delivering them. Thus, bailment implies that there is reserved to the bailer the right to claim a delivery of the property deposited in bailment, where the terms are that the bailee shall pay money or deliver some other valuable commodity to the bailer and not return the same subject matter, either in its original or altered form. This is a transfer of property for value. It is a sale and not a bailment. And where we will go to the very difference between sale and barter, where two persons mutually transfer the ownership of one thing for the ownership of another. Neither thing or both things being money, only the transaction is called an exchange. But if the consideration for transfer of the ownership consists partly of the delivery of goods and partly the payment of money, it seems that the transaction is a contract of sale. And now we'll differentiate between sale and gift. Gift is a transfer of property made voluntarily and without consideration, while sale is transfer of property with consideration. And now we'll go to question number 10, that is distinguish hire purchase agreements from contract of sale of goods on installment basis. And in connection to that, we will discuss a very important leading case, and that is Mahabali Prasad versus H.N. Almer in 1932, decided by the Allahabad High Court. So, the very question is that the answer to this very question is the difference between a contract of sale at a price payable by installment and a contract of hire purchase is that in the former the purchaser has no option to terminate the contract and return the chattel, whereas in the latter the hirer has. In the former, there is an agreement to purchase, whereas in the latter, there is none. In each case, the substance of the transaction or the agreement must be looked at and not mere words. As regarding this, we would like to analyze one example. In a case, the agreement related to queer mating valued at rupees 928, and the defendant has bound himself to pay to the plaintiff the sum of rupees 94 as monthly hire of the articles month by month in advance. It was further agreed that if he paid 10 months hire regularly on the due date, he should become the purchaser of the queer matting without further payment. If, on the other hand, he failed to pay regularly, the plaintiff had the option to cancel the transaction and terminate the agreement. The hirer himself had no such option. The agreement was interpreted as one for sale of square matting, price to be paid installments of Rs 94 per month and not a higher purchase of the matting, and it was decided in this leading case. Mohavali Prasad versus H.N. Almer. This distinguishing mark of a true hire purchase agreement, as distinguished from a sale, is that the hirer should have a right to terminate the agreement at his pleasure, and he need not continue the hiring a day longer than he desired, and he need not allow the transaction to become one of purchase unless he desired to do so. But the distinguished mark of an agreement, which is a sale and not a hire purchase agreement, is that the hirer should be bound to pay the full value of the goods by way of installments without any option to cancel the agreement if he so wished before the full value of the goods is paid. And this was also decided in this important leading case, Mohavali Prasad versus H.N. Almer in 1932 by the Allahabad High Court. And now we'll go to question number 11, and that is, what are the remedies provided by the Sale of Goods Act to a seller who has not been paid the whole of the price? In what circumstances can he stop the goods in transit? And regarding this question's answer, we found under Section 50 of the Sale of Goods Act 1930. So the very answer is that an unpaid seller has the following remedies. So the first remedy, that is, he can hold the goods as security for the unpaid price. And the second remedy, he can stop the goods in transit when the buyer has become insolvent. And the third remedy, that is, he can sell those goods to another person. So, an unpaid seller can exercise his right of stoppage in transit in the following circumstances. So, the following circumstances, the first one, the seller must be unpaid and must have parted with the possession of the goods. And the second circumstance, the property in the goods must have passed to the buyer. And the third circumstance, the buyer must be insolvent. And the fourth circumstance is that the goods must be in the course of transit, and all these are provided under Section 50 as remedies under the Sale of Goods Act 1930. And now we'll discuss question number 12, and that is the last question that we have selected under the Sale of Goods Act. And that is, what do you understand by seller's lien? And the very answer is provided under Section 47 and Section 48 Should discuss one important leading case, Martindale versus Smith, and this very case was decided under the Queen's bench. So the seller's lien, as provided under Section 47, is the right of an unpaid seller to retain possession of the goods sold until payment or tender of the price. This right is based on seller's possession of the goods. If he loses possession, there is no lien. This right can be exercised in the following cases as it is provided under Section 47. So the conditions are: first one, where the goods have been sold without any stipulation as to the credit, and the second condition, where the goods have been sold on credit but the terms of credit has expired. But if the buyer becomes insolvent, the unpaid seller becomes entitled to his right of lien at once, even though the period of credit has not yet expired. And the third condition, where buyer becomes insolvent, an unpaid seller can exercise this right even though he may be in possession of the goods as agent or bailee for the buyer. And all these are provided under Section 47 of the Sale of Goods Act 1930. And as regarding the provisions of Section 48, an unpaid seller can exercise his lien so long as he holds any part of the goods sold. The only case in which a part delivery of goods destroys the unpaid seller's lien in that in which part delivery has been made under such circumstances as to show an agreement to waive the lien, as this is provided under Section 48 of the Sale of Goods Act. And now we discuss the very decision in this leading case, Martindale versus Smith, and this case was decided under Queen's bench. Seller's lien extends only to the price of the goods. It does not extend to any other changes incurred by the seller in detaining the goods. Tender of price duly made by the buyer divest the seller's lien, as it was observed by their lordship of the Queen's bench in this important leading case, Martindale versus Smith. So, in this way, we have discussed all those 12 selected questions that we have framed on Sale of Goods Act with relevant answers as per the provisions of those sections and the very important leading cases relating to these 12 questions. So, in our next upcoming video, we'll discuss those selected questions we have framed regarding Partnership Act 1932, so also regarding negotiable instruments.